everybody. It's Rick. It is June 18, 2019. Okay, if you need to reach me, my email is rick, R-I-C-K, 0327 at me.com. The email will be in the description. Please email me only if you're serious about receiving my paperwork in exchange for a gift. I don't respond to emails and questions. What do I do and stuff like that. I'm sorry. I've been doing this for too long now. I get too many emails. Yeah. That's just not what I do anymore. When I first started, I used to try and help everybody, and 9 times out of 10, I wouldn't even get a thank you. It's just I'm kind of busy, and just dealing with the emails I receive every day from people who receive my paperwork. Okay, understand if you want to receive my paperwork. It's just for my paperwork. It's not me holding your hand leading the way, okay? That's not what I do, okay? Because you're going to go into court by yourself, okay? And you have to defend yourself. Doesn't matter. I could be on the phone with you for an hour. Doesn't matter what I say to you. You have to be practiced in this. You have to know the subject. You have to study it. You have to practice it. Doesn't matter what I say, because once you go into court and they start talking over you and ignoring you, all this stuff gets thrown out the window. Okay? What I try and do in my videos is I try to show you facts that all it is intimidation and fraud they're using against you. Okay? They start out by sending you threatening letters. Okay? And really, all it is just to trick you to show up. When they do that kind of stuff also, sometimes you'll see it on the news. I've seen it like what they'll do with deadbeat fathers or people with warrants. Also, people with who don't respond to jury duty. Okay, I've seen that. I've seen it myself. They did it with me. Before I went through any of this stuff, about 13, 14 years ago, I just moved out to Long Island, and I'm retired law enforcement, so they're never going to have me on a jury anyway. So I usually get the jury notification. And if you get it in the mail, by the way, you're not being personally served. So things get lost in the mail all the time. So I never responded. So then they sent me like a threatening letter, and I responded. I drove to the courthouse, and I walked in there, and they gave it to the clerk, and they just laughed and threw it in the garbage. Like they knew it worked. In other words, I was like one of like 30, 40 people walking through the door at 9 o'clock in the morning. And all they wanted was you to fill it out, the paperwork, okay? And they just took it and they threw it like in a basket, and they said, okay, take it easy. It was, so they do the same thing with child support. They trick you into showing up. Well, they trick you by scaring you. But you have to be personally served, okay? I went over it in the last couple of videos. Also, how many of you out there are paying child support and you live in a different state? Well, that state that you're paying child support to doesn't have jurisdiction over you. If you do not live in that state, they have no jurisdiction over you. Especially if you've never been in that state. Some of you now, if some of you started out in that state and then you moved away, okay, then the questionably they have jurisdiction over you. But if you never step foot in that state, they don't have any jurisdiction over you. And I'm going to show you in a little bit. Okay, it's called personal jurisdiction. You have to be in that state and personally served in that state for them to have personal jurisdiction for you to show up to court. But how many of you receive it in the mail? 9 times out of 10. Okay, and they rely on the trickery. They rely on threatening to suspend your license. They threaten to have you arrested. You know, so it works. And once you show up into the court, they got you. Okay, that's the reason why I have a lot of paperwork, because there's different types of paperwork that you receive, and there's different ways to respond. Okay. Also, real fast, a lot of you got to look out for the usual tricks that they pull all the time. A lot of these judges will claim that federal law is not enforceable in state court. That is untrue. Okay, there's a case law called Howlett, Howlett versus Rose. It's a Supreme Court case that says federal laws are enforceable in state courts. And they cite the Supremacy Clause, Article 6, Section 2 of the Constitution as a reason why. Just happened to a guy a few days ago with me, and I was just like, I know I used to talk about this stuff all the time, and I have some of it in my paperwork. I just moved on from it. Okay, it's very, just understand that they consider the Constitution for the United States to be federal. So if they're telling you federal law is not enforceable in state courts, you're going to say the Constitution is not enforceable here either. So, and that was basically the argument in Howlett versus Rose. Okay. All right. So listen, one of the things I have you do is I have you change your venue in the paperwork, because you are appearing in an inferior court, and you're appearing in a court not of record. It's a child support tribunal. It has all the makings of a court, but it's not. It's fake. Remember, I keep saying, they all rise, raise your right hand, and they have the bailiffs, the sheriffs there, court officers. It's all there because they're all contractors. They're being paid. They're being contracted under Title 4D to collect child support. That's how important it is. That's how important getting that Title 4D money is for the state. They use it for anything. What it is it's a recoupment of welfare. The money that you pay in child support doesn't even go to your children, because they're supposed to be receiving financial assistance called welfare, and then the state gets a grant. Okay, but anyway, let's get back to the change of venue. So what we're going to do here is we're going to demand change of venue to a court of record. Okay, and they recognize this by creating 28 U.S.C. 132. Okay, which is right down here on the subtitle A. There shall be in each judicial district a district court, which shall be a court of record known as the United States District Court. Well, if you're not in the district court, you're not in the court of record. Okay? Courts of record is a judicial tribunal, judicial, not administrative. Child support is administrative. And they try and pull the wool over your eye by telling. So let's say you're before a real judge, they try and claim that that's a judicial hearing because the judge is there. No. If it's an administrative proceeding, that judicial judge is now an administrative judge. The judge does not change the setting. You understand? That's one of the tricks that they use. It's always an administrative process. Child support is an administrative process. It's not a judicial process. And that's the reason why they tell you have no constitutional rights, because when you showed up and you didn't contest, you didn't send a responsive document contesting, and you're making a general appearance, you are now contracting with them. And then you are under their rules, under the Uniform Interstate Family Support Act. That's why they'll tell you the Constitution doesn't mean anything. So you have to respond with responsive documents recording that you are contesting the proceedings, you are not making a general appearance, and they do not have personal jurisdiction over you. Okay, well, we covered that in my last video, or the video before. The Uniform Interstate Family Support Act requires your consent under Article 2, Section 201, okay, A1, and A2. A1 and A2, or subsection 1, subsection section 2. Okay, they need your consent. So I'm going to show you. Okay, well, real fast, I'll get over here. Court not of record are those of inferior dignity which have no power to fine or imprison, and in which the proceedings are not enrolled or recorded. So they'll tell you, oh yeah, it's recorded. We're using we're audio recording. They'll try and trick you with that. Oh yeah, we record the proceedings. No, they know what a court of record is. They're just playing stupid with you. That's why you have to know the subject. That's the reason why I put this in slides, so you could actually read it. Okay, my words don't have any meaning unless you could actually see them. This is called a visual aid. I use visual aids in my videos. That way you could always go back. Okay? So, any court not of record has no authority to proceed without the consent of the persons involved. Okay? In a true judicial court, there must be an injured party in an Article 3 setting. Okay? So this is for you right here, okay? A court of record, they have power to fine or imprison for contempt. Courts not of record don't. Okay? So come back here and look at it. Okay? States have jurisdiction over non-residents who are physically present in the state. So let's say you're visiting somebody and they serve you, they got you. But if you're residing in another state and they don't personally serve you, they have no jurisdiction over you. Okay? Among the most firmly established principles of personal jurisdiction in American tradition is that the courts of a state have jurisdiction over non-residents who are physically present in the state. You have to be, your 2 feet must be inside the state. Oops, hold on a second. The view developed early that each state had the power to hail before its courts any individual who could be found within its borders. That's okay, within the state. So this is a famous Supreme Court case. We cite it all the time. I always use this case law for fake judges, coram non judice. Okay, and that's C-O-R-A-M. Some of the spellings I get in my emails are hilarious. And it's because it just shows me some of you aren't watching my videos, or you know, you're not looking at the slides. I usually show the actual spelling. This found within the boy that once having acquired jurisdiction over such a person by properly serving him or her with process. That's also in the Uniform Interstate Family Support Act, that you must be personally served. Somebody must hand a summons to you, a notice to appear. The state could return jurisdiction to enter a judgment against they. So in other words, if you're not personally served, they cannot enter a judgment against you. A lot of times they do. And that's where the fight begins. Okay? This is the case here. And these are all different interpretations. California courts may exercise personal jurisdiction over a defendant-based service or process on the defendant while the defendant is present in the state. So let's say one state is going to send a process server to another state. They have no jurisdiction over you. Okay? So let's say you live in New York and Pennsylvania wants you to appear. And they send the process server. They have no jurisdiction over you. You have to be physically in the state. Okay? Just understand that. Many of you are paying support from different states. Okay? This is the injury in fact. Okay? Respondent is innocent. Remember this. You are the respondent. When you're the respondent, you're innocent. You don't have to say anything. The burden of proof is on the plaintiff, the petitioner. Okay? And here's another thing, guys. I get the email all the time. Rick, am I the respondent or am I the petitioner? You are only the petitioner or the plaintiff when you're filing a petition. You get it? Petition, petitioner. You are a respondent because you are responding. And then you're filing motions. Okay? That's why they're free. Okay? When you file a motion, it should be free. Okay? So again, a plaintiff must show, one, that the plaintiff suffered an injury in fact that is concrete and particularized, actual or imminent, not conjectural or hypothetical. Child support is a conjectural and hypothetical injury. They're claiming, implying that the custodial parent is receiving welfare because you're not paying child support. That's the conjecture, and that's unconstitutional because there are plenty of custodial parents out there that go on welfare even when they receive support. Okay, so just understand that it must be an injured party. Okay, they must be receiving a financial assistance. Okay, welfare, to assign rights to the state to collect child support. Okay, if the custodial parent is not receiving welfare, then you shouldn't be summoned for Title 4D. Okay? And if you want to read this, go right ahead. This is just here for information. Okay, now we're going to get back to invoking sovereignty. Okay? It's very important. Okay, the Declaration of Independence makes it clear we are sovereign people. You are a people. That's why I don't like using the word person. So try not to use person, especially when you're in court. Okay? We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our prosperity, do ordain and establish this Constitution for the United States. See how it says, this Constitution for the United States of America. Not the Constitution of the United States. That's the corporate version, 1871 version. Okay, see how they play with words? We, the sovereign people, ordained and established the Constitution, which is the law of the land, to be obeyed by all elected, appointed, and hired servants. The very meaning of sovereignty is that the decree of the sovereign makes the law. Okay, so what they're really saying is we're supposed to be making a law between each other. We're supposed to not hurt each other, not injure each other. That's that's why all these traffic lights and all that stuff they're unconstitutional. Because who are you hurting? Who are you injuring? You're not injuring anybody. You're just making the county rich, or some company that owns the traffic lights. Okay. These are adjudicated facts to support your unalienable rights. Okay. And no man or woman can rule over you without your consent. Okay? Easy for you to look at. Then I'm going to move on. Okay? Some of you have probably seen these before. Okay? This is a famous one. Marbury versus Madison. We, the sovereign people, are not under management or control of government agencies. To the contrary, governments are instituted among men, deriving their just powers from the consent of the governed. You understand? They need your consent. All you have to do is say, you need my consent. Oh, no, we don't. Oh, really? What is that document called? The Declaration of Independence? I'm sure you read it in law school. Not too long. They don't spend too much time on the Constitution, by the way, from what I understand in law school. But now you have this information. Go on the computer, look up the Declaration of Independence. Empower yourselves, okay, real fast. I'm going to shut this down. I had a guy on Father's Day reach out to me. Hello, Rick. Pray you have a good end of Father's Day weekend. Your paperwork scares the crap out of these corrupt officials. My hearing went well without me getting arrested, despite me berating the judge thoroughly. He wanted to have me arrested really bad. But he couldn't because everything I stood behind was constitutionally sound in both writing and in speech. Deserve a lot of credit. You deserve a lot more credit than you have received, my friend. I'll give you full debrief once I return home. Okay? So, again, this is a guy that has studied. He knows his Constitution. He knows the paperwork. And when a judge tries to stick his or her chest out and threaten you, you could come back at them. That's what this information is here. Okay? All these case laws. All right? Okay, so I just wanted to let you guys know that you want to change your venue to a court of record, that the child support courts are inferior courts. They don't have the power to fine you or have you arrested or hold you from contempt. Think about it. How many are you in front of these fake judges? That's the sign right there. A fake judge, a judge surrogate, is a surrogate. It's a stand-in. It has no real power. If it was a real hearing, it'd have a real judge. No, that's all you need to know. Okay, so take this information, study it. Okay, understand that you have to be in the state for them to have jurisdiction over you. So if another state is having you pay child support and you've never been in that state, they have no jurisdiction over you. Now, if you had been in that state, maybe you signed some paperwork, then they may have jurisdiction over you, depending on the circumstances. But if you've never been in that state and they just sent you something in the mail, and then they start sending it to your job to have an income withholding order, they don't have personal jurisdiction. Okay? All right, guys, I'll talk to you later. Enjoy the rest of your day.